Investigations. I had asked our legal counsel, Mr. Josh Belafonte, to give us an update on the status of the subpoena for production of documents as well as the subpoena for witness testimony from Ms. Fonnie Willis. We had an update, I guess it was 4 to 6 weeks ago at our first meeting during this session, and he let us know the status of the litigation, and I just need an update to find out what's going on here as we continue to struggle to get Ms. Willis to appear and honor our subpoena. So, Mr. Belafonte, if you will, just make yourself comfortable there in a witness chair, and if you could just kind of go through some of that. My staff is making copies for us of some pleadings that you dropped off for us that in your case, but if I could get you just to kind of refresh us, give us somewhat of an overview of what actions you have taken so far to try to compel her attendance here before our committee and the status of the pending litigation, and we may have a few questions for you.
Yes, sir.
I don't think this requires a executive session, so to speak, for us to have attorney-client privilege with you unless we're at a point where you need us to advise you what course of action we need you to take as our attorney. I think we're just, you let us know if we get to that point, okay?
Yes, sir.
All righty.
Thank you, Mr. Chairman, members of the committee, and sorry for being on my phone while you were talking. I was trying to get the orders sent over to committee staff so you all can have them. Just a brief kind of timeline so you can kind of see where things are and how they started. This goes back to September 3rd of last year. That's when, after the subpoenas had been served by agreement of counsel, Ms. Willis, through counsel, filed objections and sought a temporary restraining order to prevent, I guess, the enforcement of the subpoenas at the time. That was denied on September 16, the TRO was. And then between September 16 and October 9 is really the only time until about a week ago that there's been no court order scheduling kind of deadlines and what to do. Because on October 9, the court issued a scheduling order setting a hearing for December 3rd on the merits of the objections to the subpoenas. And in the interim, we filed the counterclaim and intervening action, naming the committee as a party, as I talked about last time. Mr. Chairman, you're a party as the chairman of the committee, and President Kennedy, you are a party in your role as president of the Senate, because it deals with the Senate's authority and not just the committee's authority as well.
And remind our committee what court we filed these actions in and what's the appropriate jurisdiction to enforce a subpoena from the State Senate Investigative Committee.
It was filed in the Superior Court of Fulton County. We did it as a counterclaim to the petition to not enforce or declare the subpoenas invalid. That Fulton County has jurisdiction and is the proper venue because that's where the witness and the documents are in this case.
And that's why Governor Barnes filed the protective order or the objection to the subpoena in that court.
That's correct.
What is the judge that was assigned this case?
Originally, I believe it was Judge Williams. Well, no, originally it was Judge Schwall on the rotation, the random system in Fulton County. Judge Schwall decided there was a conflict, recused himself. It then went to Judge Williams, who originally scheduled a hearing and then shortly afterwards declared a conflict. At that point, Chief Judge of Fulton County, Ural Glanville, declared a county-wide conflict for all Superior Court judges in Fulton County. And when that happens, the Chief Judge of the county declaring the conflict will reach out to a Chief Judge of another circuit, and it will be transferred there. We've had that many times in election cases and whatnot. Then shortly after that, our current judge took the hearing, and Governor Barnes' counsel to District Attorney Willis had indicated to us and others that he was trying to get a hearing because he was concerned that she would be held in contempt for not complying with the subpoenas prior to an order. And as we explained in the hearing, at the TRO, we were not going to have the Sergeant of Arms of the Senate go out and, try to arrest the district attorney or anything like that. And frankly, because the legislature was out of session, that was not an option. So the judge ultimately held the hearing on December 3rd. And on December 20, she issued an order denying the petition to quash the subpoenas, upholding the Senate's authority to issue the subpoenas and this committee's authority to issue the subpoenas and to enforce them. But she did not compel the production of documents at that time. She said pending the district attorney's explanation of why the documents are privileged, she would not compel production at that time.
Is that where we left off at your last update?
Roughly,
All right,
yes.
So by that point, the judge had issued those orders, ordering the production of the documents, gave her a date certain to provide those documents, and if they weren't provided, to give a reason, why they were legally privileged from disclosure, either through attorney-client privilege or whatever other grounds she might have claimed.
Yes, sir.
And what was the date that disclosure was supposed to be made?
The January 13 is when the district attorney was to provide the basis of her objections, which were largely attorney-client privilege, attorney work product, and investigative privilege. On January 13, the petitioner made filed a response which made general objections, articulating the attorney-client privilege and so on, but also moved to quash the subpoenas again because the Senate or the General Assembly had that session of the General Assembly had ended. The new General Assembly came in on January 13, and so the argument was more or less a double down on their mootness argument, whereas before it was because the prior General Assembly had adjourned sine die. They now argued that this is a new General Assembly, the committee does not exist, and so the subpoenas were no longer valid. We argued that the current Senate Resolution 5 reauthorized the committee. Also, there was an issue of this was an issue that could be repeated and needed to be decided. The judge agreed with us on all of that and ordered the district attorney to provide once again any grounds for objection to the subpoena request because she reiterated that they were valid, but understood that there were scope issues in terms of what was there. But like every other party, they had to explain what was the basis of the objection. The deadline for that was those orders came out February 25 because after explaining the objections on January 13, we responded, and on January 17 was when they moved to dismiss. The court issued two orders on February 25, one denying the motion to dismiss or motion to quash, and that was the one I was just talking about, upholding this committee's authority, and ordered the district attorney to once again explain her objections to the extent that they were there. March 12 was the deadline that the court set for the district attorney to do so. On March 10, we at my firm had conversations with opposing counsel about the scope of the subpoenas and what we were looking for and so on. And candidly, given that there's not a lot of law on this issue generally, we thought the best course of action while the legislature was still in session was to at least get the documents that gave rise to the committee's formation last year and reiterating with Senate Resolution 5 again this year. So we wanted to see the documents that they had already produced in the underlying litigation that went to the Court of Appeals, where the Court of Appeals agreed on the recusal order originally issued.
Let me stop you there. What are those documents? Because what you're telling me is she is objecting in our subpoena to documents that she has already produced in other litigation that went to the Court of Appeals.
Presumably, I can't, Mr. Chairman, I can't say for certain what documents that are being objected to because we've never received an itemized list of, as you normally would. So if there's an objection and it's being withheld on attorney-client privilege or work product, typically you provide, and I think the law requires you provide a privilege log, which is where you identify the date of the document, the persons, for example, if it's a communication, who are in that communication, or if it's a memo, who drafted the memo, a general subject, so it could be, legal authority, and then the basis for the objection. We've never received that. We candidly don't know what documents they're objecting to and what documents are there. So given the need, as the General Assembly winds down, and I know that there was continued interest in this issue, what we asked is just give us what you've already given opposing counsel in the litigation that led to the Court of Appeals order. Give us the documents that you have provided to the U.S. House of Representatives pursuant to its investigatory subpoena. And the committee reserves the right to issue another subpoena. But
That underlying litigation was where the trial court disqualified her or Mr. Wade. They had to choose one of them had to withdraw from the case.
That's right.
And she then appealed that at the Court of Appeals, and they upheld that trial court order.
Yes,
Okay, and that is now being appealed to the Supreme Court.
I believe so, yes.
So there's documents that were relevant in that action to disqualify her from further prosecution of the 16 or 18 defendants that we know exist and that have been produced to somebody before, and you have an agreement with opposing counsel that we will at least receive those documents
We will
with no objection?
receive those documents without objection.
And when are we going to get them?
That's the next step. So that agreement was reached on March 10. The petitioners did respond to the court in timely on March 12. We responded to theirs and said, look, court, we have an agreement on this. We reserve the right to issue additional subpoenas. We reserve the right to do others. And by the way, there's never been an objection to the witness subpoena to come testify to this committee. And in any prior court order, it has not addressed any objections to the witness subpoena. So it is our position, filed in the litigation, that those arguments are waived. And certainly we've indicated that if she comes and a question is asked that she believes is privileged, she can assert the privilege at that time as you normally do. So to now answer more specifically your question, but with that context, the agreement was reached March 10. We did not receive documents. And so on March 18, a Tuesday, I emailed opposing counsel and asked, when can we get the documents and how? Do you need us to set up a share file system or something that, for the volume of the documents? Opposing counsel responded, and said, let me check with the client, essentially. My second email, having not received documents, went to opposing counsel March 24. I did not receive one at that time. Opposing counsel indicated to me that they had a brief or a hearing that they did, and that happens. So I sent another one the next day, March 25, and once again, opposing counsel said they will once again check with their client. And on the March 24 and 25 email, I did indicate this committee was meeting, and so they wanted an update, and I just need to know what to tell you as members of the committee. So as of today, I do not have the documents. I did ask for times that the district attorney could appear to satisfy a witness subpoena, whether we issue another one or you issue another one, or it's just done by agreement based on the old one, and indicated that the committee would like to have her testify during the legislative session. The answer I got was due to the district attorney's travel schedule and court schedule, she would not be available until late April or early May. And that's where things stand at this time. There's two other things, if I could, I would just point out that this is the first time since October 8 of last year that we do not have a court order dictating what's the next step. So previously, if we were trying to get documents or trying to get witness issues there was always an order setting up a hearing or a briefing schedule that would allow the court to decide the scope of that. That appears to no longer be the case. Also intervening on March 14, so this was 4 days after we reached the agreement on the documents with opposing counsel, 2 days after the petitioner responded to the court's order on what is the objections and privilege, an order came out in litigation also in Fulton County Superior Court, styled Merchant versus District Attorney of Fulton County. This is the Open Records Act issue that has been covered in the paper. In that case, the court found that the district attorney's office did not comply with the Open Records Act and its deadline of 3 days to explain how long it would take to get documents. Governments do not have to provide documents within 3 days unless they have them, but within 3 days of the request, 3 business days, they do have to explain, here's how long we think it'll take, here's what we think the cost might be. That didn't happen, and the court found that failure was not substantially justified. The second was they found there was a finding that the district attorney's office was handling the Open Records Act request in that situation differently than others. That typically the district attorney's office, and this is standard, I do a lot of open records issues on both sides, you get them, you often call opposing counsel and say, what are you really looking for? Is there a way to narrow this, et cetera? That was the DA office standard procedure, as the testimony indicated, but there were no calls made to the requestor, in that case the merchant firm. The court found that that was demonstrative of a lack of good faith and further showed that there was no substantial justification to the withholding the documents. As a consequence, and pursuant to the Open Records Act, the court ordered the district attorney's office to pay attorney's fees of $54,103, and that, again, came out March 14. So that's where we are, if there's any questions, I'm happy to answer them, but at this point, we will continue. The next step would be if we don't get documents, and this is where I would probably ask that we go into executive session if the committee wants to weigh in on it, but just generally, the next step would be to either move the court to compel the production pursuant to the amendment or make a finding of contempt. For the witness subpoena, I think, the committee has options there as well. I'll just leave it at that in the open session.
Questions of Mr. Belafonte from committee members? Chairman Dolezal, you're recognized first.
Thank you. Excuse me. Thank you, Mr. Chairman. Thank you, Josh, for being here. This has been going on for a year now. The DA, when we first issued the subpoena, declared in the paper that it was unlawful, when it clearly was lawful. The courts now have agreed with us that it was lawful. And I'm wondering what your advice is on how we actually get to a commitment. I know that she's saying her travel schedule is preventing that. It would appear, according to, I guess, eyewitness reports, that she's traveling with Mr. Wade again. And so do we have any ability to, I guess, distinguish between personal travel with Mr. Wade, that I don't know if that's part of why she's saying she's unavailable, versus actual official court duties? And at what point do we reach the point of either a second subpoena or enforcement of the subpoena, either with the sergeant of arms or via court order?
The existing subpoena is still on the witness subpoena is still effective. The court has ruled it is enforceable, and so whenever you have an enforceable subpoena out there and there's not compliance, you can move to compel. Now the problem is that older subpoena had a date of last year, and during that time, so you could you have options, whether again it's to issue another subpoena or move to compel that one, or just have an agreement of counsel. And in terms of which I would either recommend or proceed, I'm happy to answer here, but it might be best to do that in executive session.
It would appear to me, as a casual observer of this, and somebody who doesn't practice law, but the DA has thumbed her nose at this committee. Seemingly the DA she has thumbed her nose at Georgia's open records laws, and I just have limited confidence that she's acting in good faith. And so I do believe that we may be at the point where we need to escalate this to the next step. I think you have been trying to work this out with Mr. Barnes in good faith, and I certainly respect that. And I think that he probably is acting in good faith, but I'm not sure that his client is, and that I think is probably a concern and should be a concern for this committee.
I will say that there have been a lot of filings. There have been a lot of attempts to go to the court to get resolution, and that is what has, in many ways caused the time issue. But I will also say that the court, in every time given the opportunity, has held that this committee has the jurisdiction. The documents need to be produced, and the witness testimony should occur.
Follow up, Mr. One. Follow up.
Go right ahead.
Sure. As it relates to the order by Judge Ingram that the subpoena is lawful and should be enforced, where are we at with the DA's ability to appeal that? Are we still within a window of time where she can do that, or is that expired?
That is expired, and there is no appealable order at this time because because we reached agreement with them, there's nothing to appeal on the prior document subpoena. It is moot because there is that agreement. On the witness, we think they've waived the argument and long ago, and so that is that time is gone. And even then, it would take both the Superior Court to decide whether to allow an appeal to proceed. But that time is gone. There's no final order right now.
Thank you.
Did Senator Tillery, did you have a question?
I was going to ask what the recommendation of council as to the next step as well, if you thought it would be judicial. That seems like that would be the move at this point in time, potentially even asking the court to set a date for the either in-person testimony. Or am I correct in hearing you that you already have reached an agreement on the documents to be supplied?
Yes.
Have you reached an agreement as to the date they would be supplied?
We were frankly acting under the presumption that because they've been produced to other parties that they were available quickly.
That would be my thought.
And yeah, and that's why on March 18, I kind of asked, what's the status 24th and then again 25th. So, you know, we're at the point where I think certainly we've acted in good faith in trying to get them without involving the court. I'm not sure why the documents have not been produced at this point.
Can I ask a follow-up?
Sure.
to that? If they've been produced in another matter, were those produced under seal in that other matter?
I believe there were some that may have been produced under seal, but certainly not all. And then those that, you know, there's two issues. There's the one in the litigation and then the ones that were provided to Congress. The ones that were provided to Congress, to my knowledge, were not provided under seal. And so those, again, you know, have been produced. I know typically you just keep that kind of batch ready to go.
So we're probably talking about a small number of documents that aren't already publicly available, correct?
Those that were provided to Congress, presumably, you know, any individual could get through a Freedom of Information Act request. Well, no, that's Congress, they're exempt. So, well, now with the Open Records Act applying to district attorneys and their offices, that would cover at least those provided to Congress unless there was a specific reason to withhold them under the Open Records Act. For those produced in the litigation, you know, it's kind of new area, but I would think they're subject to the Open Records Act as well.
So I guess I've kind of walked you up to my ultimate question of what would be the holdup now? Why could they not be literally provided within hours?
Senator, I can't answer that question. I just don't know. I would.
We've not been given an excuse, though, right?
What we've been, you know, what we've been told is that counsel is checking with its client or their client, and that's where it lands, or that's where it sits today.
Other questions? So I'll tell the committee, I, of course, communicated with Mr. Belafonte, and my thought was because I'd had such a professional relationship with Governor Barnes as far as scheduling the original depositions, et cetera, that we would just reach out to him and say, when can we expect the documents? We'd reached agreement as to which documents they would voluntarily produce without raising privilege or objecting in any way. And that narrowed the scope of what we originally asked for, but at least got us going.
That's correct.
And so far, those documents have not been produced because counsel is waiting on his client, Fonnie Willis, to tell him when she can give us those documents. Is that the summary of the document production?
It is.
And then I also ask you, just in a professional cooperation manner, to reach out to Governor Barnes to give us a date for the deposition. My thinking was the same way we did it last time. If they would agree a convenient date, we'd make sure our committee can meet, and I'd issue the subpoena for that date. And your response, his response to that was, well, it's going to be late April or May because of her travel and trial schedules. Hadn't given you a date yet?
No, but in fairness, I think they were waiting for us to propose dates either within that window or respond to that that statement.
I'm going to instruct you then to give them some dates.
Okay?
In my experience as a litigator, attorney schedules are busy at the first of the week because trials usually begin on Mondays and jury selection Tuesdays. So I'm going to say, let's go with a Thursday or Friday.
Okay.
That will lessen the likelihood that she has a legal conflict to appear in a court matter. I think this takes precedence over most of those. I mean, if she's engaged in a criminal trial where she's the prosecuting attorney, that's a different deal. But they've got over 100 attorneys in that office that can handle most motions, et cetera. Why don't anybody on the committee that knows of Thursdays or Fridays that you got a particular conflict, and I'm talking late April to the, let's just look at the last week of April, the first 2 weeks of May to start with, okay? Float those dates. If anybody here knows you're on a trip or out of town and want to be here for it, let us know and we'll work around that. But give her counsel some choices and say, we will be here. Pick a date. And then we'll issue the subpoena on that date. Now, is that agreeable to everybody, or does that sound like I mean, I don't think we have to go in executive session to try to be cooperative with opposing counsel. Okay. And then on the documents, I think you're going to have to just do a letter that says, by golly, here's the date. You know, and it needs to be before we have her here to testify so that we can be prepared to question her. So I would say 2 weeks from today or from this Friday, I mean, pick a date here, April 15th range. You look at something that's an end of a week and say, this is reasonable. This has been going on now since March the 12th, and follow up. And so that's more than 30 days from when they agreed to produce documents that have already been produced in other matters, right? Okay. Does that sound like a fair course of action? I'm not, you're the counsel for this committee, but that would be my suggestion if that suits.
I think the only question for the committee is, given the agreement on March 10, whether the committee wants documents while the legislature is in session, or if the committee would be satisfied getting them after sine die.
Well, I mean, we only got a week,
Right.
so
So
next Friday, sine die, so I don't believe it's going to happen. Even if it gets here, we're going to be on the floor.
Sure.
So
Right.
I don't think we'll have time for a meeting. Let's give them till April 15th
Okay.
to produce those documents, assuming that doesn't fall on a Saturday or Sunday, that have already been agreed upon.
Yes.
That surely she's not traveling out of, I mean, she's got a job to do here in Fulton County. She ought to be here within 30 days. And it's asked, and then if those documents aren't produced, then you got to file that motion to compel or whatever it is to get the court to make it again and ask for your attorney's fees. We're paying you for all your efforts and asking her to do stuff that the court's already ruled she has to do. And then we'll try to see if she will appear, and if not, at least then we have an opportunity to move to compel her attendance that the court's already ordered.
Okay.
All right. I have a few things in the file for committee members that Mr. Belafonte brought us this morning. I want to make sure we have in the record, and I'm going to let you mark them for us, and we'll give them to the court reporter to keep in our record. But there was an order that specifically ordered Ms. Willis to appear in response to her subpoena, the witness subpoena, and that was not appealed.
The order indicated that the witness subpoena was enforceable, but in the December of last year order, it grouped it with the document one and said, subject to the production, it doesn't address the witness one separately. My point on that one was there's not been an objection made by the district attorney on the enforceability or scope of the witness subpoena since last year.
Okay, so I'm looking at an order that's dated February 25th of 25.
Yes.
Order regarding petitioner's objections to witness subpoena that ordered her to file a detailed elaboration of her arguments no later than March 12th, or else abandon the objections to these requests on these
Right.
bases. And the respondent shall have until March 21st to respond. That's us.
That's us, and that's the one where we pointed out in our response that in that opportunity afforded to the district attorney by the court, there were not objections made to the witness subpoena. It
And
was
that
focused
is
on documents.
your document filed on March 12th, petitioner's brief in response to order regarding petitioner's objection, and then your
Yes.
reply. So this is the briefing of that issue.
That's correct.
All right, for our record. And no appeal to the court's order. So
No.
the next step is for us to issue the subpoena again, give them a date certain, and if she fails to appear, then we would file a motion for contempt for failing to have honored a subpoena that she's already get an order that is enforceable.
You would have several options at that point, including contempt. Yes.
All right. And then we will talk to you about which of those options to go.
All right.
Okay, so let's be nice guys again first. Let's reach out to her counsel and suggest either a Thursday or Friday in beginning the last week of April or the first 2 weeks of May.
All right.
And if they will agree to a date, then we'll issue the subpoena, and I think they will honor their word. If not, we're going to have a whole nother problem.
Right.
And the same thing on the documents, just say, we've hit the end of our rope, we need them by April 15th. You've already agreed to give them to us. And if they don't, then we'll have to circle back with you. I'm expecting we're going to probably plan a meeting for late April or early May, depending on the subpoena one way or the other.
All right.
And then we'll tell you what to do, or you'll tell us your advice, and then we'll
Sure.
choose. Senator Tiller?
Mr. Chairman, I just wonder your thoughts and the thoughts of the committee. We've gone these steps several times. Would it be appropriate, and would the committee consider authorizing counsel, if a date cannot be set for appearance before May 10th, to authorize him to file a motion with the court, asking the court to set the date for the personal appearance?
What do you think? Let's say they don't agree, they don't play nice, that we're trying to be professional and they won't agree to a date. Would that be an option for you to
That would
do?
be an option. I think also the committee could issue a subpoena setting a date unilaterally, and then they would have opportunities at that point, if they can't make it, to move to quash or whatever else. Or if we don't get a date, I think we could just ask the court, indicate it almost like a status conference, and ask for guidance from the court in an order setting a date, so that, given that we've already gone through all the objections, right? I mean, the only objection left would be something like trial schedule or something of that nature, which is why I think you've given a large window to help avoid that.
Mr. Chairman, if I may, Mr. Belafonte, the reason I'll bring up that option is if we file a motion, then we're going to have a motion to quash.
Correct.
Then we're going to have a hearing on the motion to quash, and we're going to be back in this, I think, wheel that we've been on for the past a year already. If the committee feels like it's a wise move, I at least I'm willing to make the motion if the committee wants to consider, at least for consideration, that if personal appearance cannot be set by May 10th, that we would file a motion with the court, that the court set the date for personal appearance and testimony on the matters that they've already ruled are legally binding.
Is that to basically give us a shortcut or expedite matters to do it that way?
Pending agreement with the court, of course, but it is an option to present to the court and to help shortcut that, for sure.
Senator Hatchett, you're recognized.
Yep. And this may be a conversation that would be more appropriate in executive session, but as I start, if it needs to go to an executive session, you just tell me to stop. But 6.4, that I'm assuming that rule would apply here.
Yes.
And that, if we send a 6.4 letter to resolve a discovery dispute and we're not able to get it, then we could actually motion for a 6.4 hearing on those specific issues, and that could be the vehicle in which to get the court to set a date for the documents and for her to appear.
That is another option.
Okay.
Yes, Senator.
Go ahead.
Not get ahead of you, Mr. Chairman, but if you're comfortable with that, I'll make that in a form of a motion.
Basically, it would be if they don't voluntarily agree to select one of these dates in the next, the end of April, the first 2 weeks of May, to ask the court's intervention to set the date.
To set the date.
All right. I'll accept that as a motion. Anybody want to second that? Got a second, Vice Chairman. Any discussion of that course of action? All right, all in agreement with that, raise your hand. 1, 2, 3, 4, 5. All opposed? 2 opposed.
And, Mr. Chairman, I have another motion I'd like to make second
Right.
to that, if you
Let's
don't
hear
mind. Should we end up in the position that we have to move forward with forcing a hearing because we can't set one by agreement, then I would move that we instruct counsel to request all fees for all time involved in anything concerning his cost, attorney's fees, for anything concerning the matters of appearance and document production after May the 10th.
I don't even think we need a motion for that. You're going to do that, aren't you?
Sounds like it, sir.
I mean, why wouldn't
Yeah.
you?
No,
We're paying you.
Yep.
Yeah. Yeah, you don't have to have a formal motion. That's your instructions. Make her comply, and if she won't, make her pay for your fees for making her do what the judge has already told her she's got to do.
All right.
Okay, because Fulton County's already shown that they'll do that if they snub their nose at open records requests. So this seems to me more important than an open records request, an actual subpoena.
Okay.
That's been enforced by the court's order.
Right.
Yes, Senator Gooch,
I'm
you're
going to
recognized.
ask a question. I think I may know the answer. What would typically happen if a district attorney like Ms. Willis issues a subpoena and the person that she issued that subpoena for just ignored it and neglected to appear?
That person could be held in criminal contempt.
Okay. Arrested?
Could be.
Okay. Thank you.
Other questions from committee members? Senator Dolezal.
Mr. Belafonte, what is our legal obligation to show deference to her personal travel schedule? Because I suspect that after a year of seeing her thumb her nose at this committee, I made a couple notes of what the court said in the open records case. They called her office openly hostile and substantially groundless and vexatious. You overlay that with the odor of mendacity comments that other judges have had, and I think that what we have here is an individual who thinks she's above the law. And I don't think that the people of Georgia want this committee to wait for her to decide that she wants to appear based on her either her travel schedule, Mr. Wade, her travel schedule otherwise, or the court thing. I think we would have, obviously, understanding of. But what is our requirement to defer to her personal travel schedule?
There is not one. It could be a ground to quash the subpoena, and then the court could decide how to proceed with that. But the committee has no obligation to, unless there's a leave of absence filed in a case or something of that nature, which we don't have in this context. But to answer your question, there's not one.
Thank you.
Okay, I'm going to mark the documents that the orders regarding the production of documents and the responses and reply briefs that are record, so we can have that in our record. We also have in our folder a draft of minutes from our last meeting that we need to approve, if y'all take a minute to review those. This was our February 20th meeting, our organizational meeting, and we got litigation update from Mr. Belafonte at that meeting as well.
Motion to approve.
All right, we've got a motion to approve. Is there a second? Second by Senator Kennedy. All in favor, raise your hand. Any opposed? All right, those pass unanimously. All right, having done that, that will conclude our business. We will wait to hear from you as to whether or not you're able to reach an agreement as to the date that she will appear to respond to her witness subpoena. And as soon as you get the documents, please share them with the committee.
All right.
And with that, we are adjourned. Thank you very much.
Thank you.